Good afternoon. Thank you for joining us. It's terrific to see so many people out. And unsurprising, our topic for today, current developments in ERISA law, is of great interest. No, thank you for joining us for what is, clearly you agree, a timely and important set of issues around the constitutional separation of powers and the capacity of our system to check, in particular, the exercise of executive power. We have the best possible panel here to help us explore those topics. Each of them is entitled to an introduction that would last the entire session, so none of them will get one at all, really. I will just, in very brief form, say that we're delighted to welcome my former Columbia Law colleague, Jillian Metzger, who's a professor at Columbia Law School, our own Bob Bauer, who of course teaches here at NYU, and Michael McConnell from the Stanford Law faculty, who's joining us once again as a visitor this fall. Each of our guests also, of course, has deep experience in public service. Jillian, in particular, in the Office of Legal Counsel during the last administration as deputy, and for a couple of months as acting head. Bob as White House counsel, among other roles he's played during the Obama administration, and Michael as a judge on the 10th Circuit Court of Appeals for a number of years, among other roles. I'm Trevor Morrison. I teach here at the law school. I was the dean of the school for 9 years, and now I'm very glad to be back teaching and glad to welcome all of you. So we're going to have a conversation, or attempt to have one, in front of all of you about these issues of the constitutional separation of powers and presidential power in particular. We're going to do our best to reserve some time at the end for questions from all of you, and we'll welcome those, and I'll let you know when we hit that point, but just to orient you, at that point, if you have a question, you should line up and speak into one of these two mics so that everyone can hear you and we can record it as well. So without further ado, let's get started. So I think we all have a picture here about how the constitutional system of checks and balances is supposed to work. James Madison in the Federalist Papers told us that the design is one that is meant to cause ambition to be made to check ambition, with in particular the political branches, the legislative and executive branches, checking incursions by the other into their own set of institutional prerogatives. And it was Justice Jackson, in his famous concurring opinion in the Youngstown steel seizure case from the middle of the 20th century, who said that when we think about presidential power in particular, the most important question to ask is, what has Congress said? That there is an inevitable interaction between executive power and legislative power, and that the president is on shakiest footing when he takes or directs action that is prohibited by Congress, or that is not approved by Congress, and indeed that courts have been and would be expected to be most inclined to invalidate executive action when it flies in the face of statutory prohibition. Those are some of the general elements of the conventional picture of how things are supposed to work. We're going to be talking about how things are going in this still relatively new Trump administration. But before we can do that, we should probably talk about whether that picture had been working very well even before this administration. How had it been working in the recent past? Does this picture of legislative checking of the president and then a judicial enforcement of those checks well describe how things were working during the George W. Bush administration, or the Obama administration, or Trump's first term, or the Biden administration? And then we can ask how it's going in Trump's second term. But Professor Metzger, maybe I'll start with you. Does this picture describe things, how they were working up until this past January, or not?
I think mixed. You certainly, before this last term, had very aggressive executive assertions of authority, somewhat unilaterally. You also, however, had a number of major statutes enacted by Congress over those periods, right? You can start with Bush with the No Child Left Behind, to Affordable Care Act, to Dodd-Frank, and then the CARES Act and the Inflation Reduction Act under Biden, and the CHIPS Act. So lots of big statutory measures pushing through the administration's agenda through legislation as well as through executive action. You certainly also did have a lot of judicial invalidation, for sure, right? You had depending on which administration was in power, different circuit courts were more or less active, but certainly under the most recent Biden administration, you had a lot of activity in the Fifth Circuit in particular. And so those trends were there, but you also really had an expansion of executive authority.
Mm-hmm. Professor Bauer?
I certainly agree with that. I think we have a long background to the Trump presidency, which is unique in many respects. I'm not going to suggest that it's a seamless transition from the past to the present, but a long history of continuous presidential pressure against norms and in some cases legal constraints, presidential self-aggrandizement if you want to refer to it. And there are just so many different pieces to how that picture doesn't quite fit the reality over many decades. I want to add also that, you know, in a very famous article, our own Rick Pildes and Darrell Levinson wrote about the separation of parties and not powers. And presidents have been operating in a world in which Congress steadily, because of partisan alignments and rabid partisanship for that matter, does not police institutional boundaries. And so the role that it would play in ensuring that the president doesn't completely exceed all bounds in seeking out authority, that congressional responsibility has been largely abrogated.
Professor McConnell, how about that? And maybe I'd ask you to address a kind of follow-on question. Is it, in this context, meaningful to talk about assertions of executive power where Congress hasn't spoken meaningfully and assertions of executive power that would seem to be, or clearly are, contrary to what Congress has said? And has there been any particular pattern pre-Trump administration with respect to that distinction?
So those are two different questions, so I'll talk twice as long.
Indeed, yeah.
That's not hard to get me to do. I don't think that there's much doubt that President Trump is hitting new highs or lows, depending on how you look at it. He's taking things to more of an extreme than have been taken, but as the others said, almost everything that he's done has a precedent in the last few years before that. I say almost, not quite everything, but most. Now, he takes them to even further extremes, but do we dislike using the Justice Department to prosecute political enemies? Well, what happened to Donald Trump, and what happened during the whole Russia Gate episode? Do we like not obeying Congress's control over the spending power? Well, what do we do with the fact that, you know, the previous presidents actually were reversed by courts because of either spending money that wasn't appropriated or refusing to spend money that was appropriated? So there are precedents, but I want to say this, want to stress that this is not just to sort of cast blame on, you know, prior administrations. I want to look forward. I think we need to think about what lesson do we get from this? And the lesson that I get from this is that it is really important for those of us who believe in the rule of law to police our own side. That the problem in many of these cases is, so Joe Biden decides to spend $430 billion on loan forgiveness without authorization. How much complaint was there? I mean, I don't know. Jillian, Bob, were you writing op-eds complaining about what a serious violation that is? Maybe you did. I just don't remember. But that's the problem. Is that the people of the president's party just sort of tend to wax happy. And I just told my Republican friends now, you like what Trump is doing, well, wait until the next party, the other party is in power again, and that's being done to you. Think what the Democrats can do to any conservatives in higher education or to their enemies. So I really urge people in this room not just to like blame each other. That's not the point. It's that we all have a responsibility. Now, Trevor asked me a second question, which has to do with whether this framework, which is famously set forth by Justice Robert Jackson in his concurrence in the steel seizure case, Youngstown Sheet and Tube, where he talks about the importance of looking at whether actions by the president were either authorized or forbidden by Congress. And I think there are a lot of theoretical problems with that. You can read about them in my book, which, by the way, on Amazon, easily available. It's called The President Who Would Not Be King. But I'm not going to talk about high theory. As a matter of litigating practicality, and I'm deeply engaged in litigating the tariff case right now, as a matter of litigating practicality, this formulation is virtually useless. And the reason it's useless is that everything in the litigation, and this is not just the tariff case, but every one of these presidential power cases going back for every administration, they all take the same form, and the form that they take is that the president never admits that he's doing something without congressional authorization. The president always can find some vague language in some old statute that he can twist into looking like authorization. So they go and say, "Hey, we're a Category 1 case. We're just doing what Congress said," and Jackson doesn't tell us what we do about the statutory interpretation side of this. Do we lean in favor of deferring to executive interpretation? I mean, we used to do that with the Chevron doctrine. Thank goodness Chevron is behind us. But now the major questions doctrine sort of leans the other way against executive action. I'm rather in favor of that. But either way, Jackson's formulation doesn't tell us. And then just finally, the other half of this is, how do you know whether the president is actually violating a statute? It's one thing to say he has no authorization. A second thing is he's in violation. And in the steel seizure case, the court said he was in violation, even though there was no statute that said you can't seize the steel mills. What the statutes did is they had alternative means by which the president might have accomplished what he wanted to do, but the president thought those were too cumbersome and awkward to follow. Well, this is also true in almost every bit of this litigation. In the tariff case, for example, does it matter that Congress has passed 5 different statutes giving the president authority to impose tariffs under very limited circumstances? I think it matters, but government argues it doesn't matter at all.
Anyone want to add anything on this point?
I just wanted to say one thing. I have written critically of other Democratic administrations, but always under pseudonyms. I do want to mention, I think it is fair to say, this has been a large issue for a long time, but I do want to stress, because you said President Trump's taken his new highs and two lows, depending on how you look at it. But, consider the point we've reached where the president can refuse to enforce a statute passed by Congress by large majorities and held to be constitutional unchallenged by the Supreme Court, and that was the TikTok ban. That he just simply said, yes, there was a brief pass at giving by presidential executive order, if I remember correctly, some sort of apparent authority he had to safeguard our national security under Article 2 to suspend the operation of the statute while he looked for different ways to save TikTok for American customers, but he refused to enforce the statute. I don't know, and I could be wrong, of any parallel in modern American presidential history where a president says, I'm not going to enforce the statute. I'm just not going to enforce it at all.
DAPA and DACA.
I don't think that was a question of priorities enforcement, not non-enforcement altogether. I think there are 2 issues here that are possible pitfalls, and both need to be recognized. So one is certainly to claim that the Trump administration is doing something new that never has been done before. There hasn't been excesses of executive authority before. That would be false. It's equally, I think, wrong to do some false equating of the situation that we're in right now in terms of the degree and the scope and the expanse of violations of statutes and the deviations from the norms and laws that used to govern the executive branch that are going on right now. I think we have to be able to balance both of those. I don't think that we can claim that there weren't some violations if you focus on the spending. The student loan case is one example people bring out. I also think that you can argue that there was a claim of statutory authority, which is different than some of the claims of impoundment, pocket rescissions, and others that are going on with this administration. Yeah, you can make these arguments. TikTok ban is one example. What's happening in the Caribbean is another example. I think we just have to be able to balance these 2 points and not lose the nuance that both can be true.
So we should start talking about some specific issues, maybe in a little bit of greater detail. I will say that, and maybe some or all of you have experienced this too, my non-lawyer friends and relatives are bewildered by many things, as am I, but one is, how is this impoundment thing possible? How is it that the president can simply refuse to spend funds or order the expenditures that have been appropriated by Congress stop if Congress has directed that those expenditures be made? And maybe we can sort of talk a little bit for our audience here about what the shape of that problem is. My own sense is that the administration and its defenses of this has been a little bit of a shifting target too from the beginning of the administration till now. One heard a little bit more in the first weeks of the administration, I think, about an idea that the president might have a kind of roving, constitutionally based power of impoundment. And one seems to hear much more these days assertions that a particular statute or a particular appropriation grants to the president a measure of discretion, and that the withholding of funds is an exercise of that conferred discretion, which comes back to Michael's point about how can you tell whether a statute has been violated or not. But maybe the question I want to ask in general form is this a big deal? Is this sort of set of withholding of expenditures something that we should think is of very high constitutional moment? Or is it not such big a deal because at the end of the day, it's only going to be upheld to the extent that it's within statutory authorization, and that boundary will be policed well? Thoughts?
Well, I'm happy to lead off again, but I'm sure you guys will jump in. And one of the things that's fascinating, and this is coming from someone who wrote an article about how appropriations were marginalized in administrative law. No more, I think we can say officially. But it's really, appropriations have always been controlled through political constraints. There is just an elaborate set of regulations and controls internal to the executive branch, appropriations offices that control spending, OMB, and relations. And there's just tremendous back and forth with the appropriations committees of Congress and the subcommittees, and a lot of consultation that goes on. That's the normal process. And you'd occasionally have claims of GAO also polices. You get claims of Anti-Deficiency Act violations, and sometimes OMB and GAO might disagree. But there was the system was one that really operated largely on its own track outside of courts. And there's a lot of reasons for that. You need to have flexibility to be able to shift funds around. There's a lot of reason why you have transfer and reprogramming statutes that allow that. What we're seeing now, I think, is just a different magnitude and something we really haven't seen before. And when those norms of cooperation and consultation dissipate, it's very hard to figure out what are going to be the controls in their place. Litigation is an obvious alternative. There are certainly statutes that are being violated. There are sometimes appropriation statutes that are very specific. Often in those cases, I think the government is ending up paying. I think you're absolutely right, Trevor, that they began with a broad claim of impoundment power, and then they have switched more to a statutory basis. But this power of the purse is really essential to how government operates and to preserving constraints on the executive. So to lose the power, which has had such historical importance, it is also the case that the funding the government is where Congress really exercises its control. It doesn't pass a lot of statutes, but you know what well, sorry, this is not a good time to make this point, but usually it passes.
When it's open.
When it's open. But really, the appropriations bills have been the way a lot of stuff that needs to get enacted is get enacted because the budget has to be enacted. And so to lose that power, which has become such a linchpin in our polarized politics, is also critical and problematic from Congress's perspective as well.
Why are the courts as apparently limited thus far as they apparently are in being able to constrain the president with respect to a kind of refusal to spend appropriated funds? Why is that as hard as it is?
Well, standing is part of it because I don't have any doubt, and maybe some people do, but I don't have any doubt that direct beneficiaries of spending have standing. Like if I'm entitled to get money,
right,
and it's not being, I think I have standing, and I think the Clinton v. New York cases are clear, and I think the Nixon era impoundment cases are clear. The cases that have come so far have not been that. They've been people who benefit from the programs that are where money goes to like X organization, and they provide services, and those people have been held not to have standing. And I have to say, I think that's a correct interpretation of standing doctrine. I'm very worried, though, about spending money that hasn't been appropriated. That's not been the biggest thing under Trump, but it's an equally dangerous assault on the power of the purse. And here, standing, it's very hard to think of somebody who really has standing to challenge that, given that the Supreme Court decision, Massachusetts versus Mellon from the 1920s, has been interpreted, I think perhaps incorrectly, but interpreted to hold that taxpayers don't have standing. Taxpayers are, in fact, the people who are injured when the president spends money that hasn't been appropriated, and maybe nobody else. And so look at the cases. The immigration cases came down to whether Texas, it loses a little bit of money on the producing driver's licenses. The Biden student loan case standing came down to whether Mohela, which is this obscure state agency that administers student loans, they lose some, a little bit of their profit because of this, which is, and I think as a matter of state law, they probably didn't have standing either. But
and they didn't sue.
These big cases, the big cases where the court has stood up on the spending have been based upon standing claims that are so tenuous, and I think this is a really big problem, is the lack of a standing doctrine that really enables the courts to step in.
I just want two quick points. I don't disagree with the analysis on either side of me here at the moment. I just want to add, again, we have to go back to all the tools that are available to Congress to potentially penalize the president, for example, for not following the norms or otherwise simply not engaging lawfully with the Congress and following their spending mandates. Congress doesn't do that. And so, again, I just want to stress, executive authority here is a large problem. That is to say, abuses of executive authority and the continual pushing of the envelope. But Congress's role can't be ignored here. And what we have seen, both in the presidency and the Congress, is a loss of any sense of institutional identity. Members of Congress see themselves as representatives of political parties who have responsibilities to their party and to the president align with them in their party affiliation. But standing up for institutional prerogatives and defending them has simply slid way down the scale of priorities. And really, they only respond when there's enormous public pressure from underneath because there's public unhappiness with some aspect of executive behavior that then Congress is called upon to respond to. The other thing I just wanted to quickly add to this is the administration's various efforts, and it seems unlikely right now it's going to bring a constitutional challenge to impoundment, which originally Trump indicated he was going to do.
To the Impoundment Control Act.
To the Impoundment
Right.
Control Act.
Yeah.
He said that Nixon was right. Nixon had said it was absolutely clear that he could impound funds, and Congress responded by enacting a statute to make it clear he was absolutely wrong about that. But there are a lot of different ways this comes up, and an example is refusal to spend money that Congress has appropriated, for example, for standing departments and the functions that they discharge. And this is being passed off by the administration as workforce reductions in the interests of government efficiency, in which, as a practical matter, these agencies that have financial backing from the Congress to perform certain statutory functions are unable to do so because they've been hollowed out by firings. And I bring that up because that is a bank shot in simply refusing to spend money that Congress has appropriated to affect certain functions that are assigned to departments of the government.
Can I just add something here to the first part of what Bob was saying about Congress isn't doing anything, which is of course true, but it isn't true forever. We have been in a long-term pattern politically in which, when a president is elected, his party controls Congress for the first 2 years of the administration, but that has flipped. And I guarantee if the Democrats take over Congress after the midterm elections, you're going to see a lot of activity from Congress, maybe even too much. Because, I mean, they often do like dumb things like impeachment rather than smart things like getting the power of the purse back in their hands. But the American people will decide, and if the American people decide that they like what Donald Trump has been doing and return a Republican Congress, it's going to be just like this for another 3 years.
One thing to add, particularly on the judicial court problem, it isn't just standing. What we're really seeing a lot of is preclusion. The courts are reading the standard ways to get into court to challenge executive action through the APA as precluded. You can't sue under the Impoundment Control Act. You can't sue to enforce it under the APA is one main example. A lot of the instances, and these are instances where people really do have standing, they have grants that have been terminated. And the court has held in a vast number of those cases. The court has ruled on 2 cases, but they basically said you can't get in, it's precluded, you're supposed to bring those claims in the Court of Federal Claims. And this is actually a broader trend in the court in terms of pulling back on implied equitable actions and equitable actions in other ways. And that's playing, I think, a very significant role in this area in particular. So even if you do get in, even if you do have standing, you're going to run into a cause of action problem.
Could we use that as a way to transition to talk about sort of disaggregating the judiciary a little bit? I mean, one theme, and maybe it's just a really transitory thing or something, but if one looks at court decisions issued in cases challenging actions taken by the Trump administration, in contrast to earlier administrations where, you know, the administration would win some, lose some, but there didn't seem to be as stark a division between how cases were tending to come out in the lower courts and how cases are tending to come out in the Supreme Court. At least in the last 8 or 9 months, though, in a bipartisan way, district court judges, and not quite as uniformly, but a majority of Court of Appeals panels, whether or not the panel is 3 Democratic appointees or 3 Republican appointees or more mixed, have been applying what they thought were the sort of conventionally available doctrinal tools and calling different executive actions out of bounds with respect to that. And not uniformly, and the Supreme Court has, you know, decided far fewer of these issues thus far than the lower courts have, just in the nature of things. But there's been a kind of reorientation of the doctrine in different spaces. Preclusion is a great example, saying actually APA is not available for a set of things that most of the judges in the District of Columbia, I think, thought it was available for. And you've got to go to Court of Federal Claims. And that might be the right answer legally, but is there anything to make of this apparent, stable for now, contrast between how the lower courts have been reacting to what they see as quite novel assertions of executive power and how the Supreme Court has been reacting? And what do you make of that? Mike?
I think there's a structural feature of our litigation system that I think accounts for this, which is that plaintiffs, with some exceptions, plaintiffs get to choose where they sue. And so plaintiffs challenging the administration actions get to go, they'll mostly sue in San Francisco or Seattle or Boston, sometimes in Maryland.
Not Texas anymore?
And when Republicans are challenging the decision, it was exactly the same. This is a totally bipartisan issue, or it's not an issue, it's just a fact. Republicans sued in Texas or Louisiana, and this skews the lower court decisions. I'm not saying judges decide cases according to politics, but where on the margins, politics affects. And then the second thing that I think is important is that the Solicitor General gets to control which cases he takes up to the Supreme Court on an emergency basis. And the Solicitor General is not an idiot. He takes the cases that he's most likely to prevail on. And so it's just not surprising that that you have a very different complexion of decisions at the lower courts than you have from the Supreme Court. And then the final thing is that most of these cases have been decided on an emergency basis because of preliminary injunctions or the like, without full hearings, without full decisions, without briefing, without argument, and many constitutional challenges are, I mean, some are pure questions of law, but a lot of them have to do with judgments about what the real facts on the ground are, and gets up to the Supreme Court, and I think the Supreme Court has a tendency, and I don't think it's even a bad one, and Republican and Democratic presidents alike, to give the administration a presumption that what they're saying is the truth on the ground is, and then if there's a full hearing and so forth, it may be different. I suspect that when the cases are getting up to the court that have been fully litigated, I don't think the same pattern is necessarily going to prevail. And there are three up there now that I think the administration, it's quite possible the administration will lose all three.
I wish they would lose Slaughter, but I'm less optimistic.
Actually, I take that. You're right. I don't.
I was loving this.
I don't know. Why did I say all three? Two of the three.
Tell us the issues in the three.
Sorry?
What are the issues in the three cases you have?
Oh, so as Jillian mentioned, Slaughter is the question of whether Humphrey's executor is going to be overruled.
And it is.
And it will be. It will be, and it should be. I might not write a constitution that way, but that's the way it is. The other two are the tariff case and then I thought that the birthright citizenship is up there. I think there's a reasonable shot. I think there's a very good shot that birthright citizenship is going to go against the administration. And I mean, it's my case, so you can guess what I think about whether I'm going to win.
Bob?
No, I heard Jillian say something to this. I was going to mention, I think we may see an odd, and you might disagree, Michael, an odd result in the Fed removal case involving Lisa Cook, Fed Governor Lisa Cook. The court has already expressed kind of this, I wouldn't say doctrinally pure reservation about extending presidential removal authority to members of the Fed. There's sort of a line about some distinctive historical function it's played. Who knows where that ultimately goes? Again, that was in an emergency setting, but she was allowed to remain for the time being while the case is pending. And so I think that only goes to say, I don't even know that Humphrey's executor is going to be 100% overruled. There may be some, I don't know what you want to call it, spin on the ball that the court puts on it to save itself in some situations. I do want to add, your question, I thought, Trevor, goes at this worry people have that because the Supreme Court doesn't seem to be in line with the lower courts, there's something going on there at the Supreme Court level that we should be actively concerned about, some evidence of partisanship, effort to sort of support Trump, which I think is a way oversimplified picture, and much of what Michael just said I agree with about the possibility that pattern may not hold. And I also think we have to keep in mind the Supreme Court has been inundated with exceptional challenges, if you will, over a short period of time. If there's, I haven't compared it to prior historical periods or decided sort of how it fits in with the role of the court in the New Deal, but the speed at which this has all been happening, I think puts the court to having to make some very, very hard choices. And I'm now speaking to the conservative majority and not to the regular dissents that we see from Jackson and Kagan and from Sotomayor. And I don't think it's sorted out what it's going to do yet. I mean, my view is that it doesn't know what to do. And here's the, I'd be very interested to see if I'm just comforting myself in the middle of the night. Because it did not, no one anticipated that this particular government would operate the way that it has. At least not many that I saw anticipated it. And so the court, on the one hand, is traveling down certain well-trod doctrinal paths, like the unitary executive as a just sort of a fundamental constitutional view of executive authority, and now they're having to analyze that case in light of a very specific and extraordinary experience in modern presidential history. They had, I think, not a very clear idea of where this could go, and I think the Fed case is an example. So I'm not sure we're not going to see a few surprises along the way.
I like the optimism there.
You like the what, pardon?
The optimism. I'm loving the optimism of my colleagues here. It's great. There are just a couple of factors I think it's worth adding in. I actually agree with the forum selection is obviously playing a role, and the SG's appeals as well. There are some other dynamics that are, I think, worth flagging. One is you are seeing a number of district court judges express a degree of concern about truthfulness and credibility from the Department of Justice that I have never seen before. I think that is worth noting. I think that does play into how the courts are viewing the government's claims. The Just Security here just did a great report on what's happening with the presumption of regularity and how the number of times that you're seeing district court judges make comments that are at odds with that. You had the New York Times article where they surveyed some judges. That is all new, you know, there's a problem for any next administration having lost this much credibility with the judiciary. But I think this is playing into how the courts are really responding to these cases. There's also the fact that you have these district court judges under very short time frames. They are writing lengthy, thoughtful opinions. They are actually dealing with the facts in some detail. And it's on a speedy basis, but they're engaging, they're putting it out there. And then it goes up to the Supreme Court, and they get a stay without any explanation. There are a lot of good reasons why the Supreme Court doesn't explain on the emergency docket. I get it. But that's not a conducive way to have goodwill among your judiciary when they're really putting out their ideas and trying to take this seriously and expressing their concerns and maybe feel they're not hearing from the court. And then I would add one final thing to that, which is there has been a little bit of arrogance, to put it in my view mildly, in some of the comments from the Supreme Court. I'm thinking particularly of Justice Gorsuch's concurrence, where he accused the district court judges of defying the Supreme Court. Whether or not that's what he thinks, to put that in an opinion, and particularly in the area in which he put it, where in fact the Supreme Court itself is deviating from what its past precedent has been, and to sort of lambaste the district courts for that, was really extraordinary. So there is also, I think, just some relationship building and repair that needs to happen.
There's even disagreement among the 9 of them over what that precedent had meant. And so it's quite something to accuse a lower court judge of, abdication of duty because he simply agreed with some of Justice Gorsuch's colleagues as to what the decision had meant. This putting out of the presumption of regularity coming under stress, I think, is an important point, and it has. You're right. Our colleagues at Just Security have done some really exhaustive work in that space. And it does seem to be an example of where we could be in a situation where the judiciary's resources, their doctrinal resources, sort of run out. I mean, the function of the presumption of regularity has been to give the government sufficient incentive to get the benefit of the presumption that they never rebut it. And so we don't have great doctrinal development of what happens when the presumption is rebutted. And yet at least lower courts seem prepared to say that it has been. And so what follows? And what do we think the Supreme Court's going to do about this? Is it just going to, sort of do conventional legal analysis, or are we actually likely to have new doctrine here? For example, in the tariff context, IEPA has been invoked by presidents of both administrations. It's really easy for a president to declare an emergency, and since the court erroneously struck down the legislative veto and outrageously held it to be severable from the rest of the statute, there's basically no way for Congress to police the exercise of that power the way it intended to. And so we have open-ended emergencies and use of IEPA authority for lots of different things. And now we have use of it for something that it's really never been used for before. But do the courts have great resources in their existing doctrine to know how to ensure that Professor McConnell wins? Professor McConnell?
Oh, sure. The presumption of regularity I think, actually has relatively little to do with the tariff case itself.
Yeah, no, fair enough.
So one question is whether IEPA, if it applies, IEPA is the International Emergency Economic Powers Act, whether the language of having a power to regulate importation gives the executive the power to impose tariffs. That's one question. There is a second question, which is that IEPA also says that the authorities can only be used in case of an unusual or extraordinary threat to national interests. And here I think the presumption of regularity might kick in a little bit because the president's executive order says, well, this meets that, except that 9 times in the executive order, he calls the deficit, the trade deficit, persistent. And, you know, I've been speaking English much of my life, and I would have said that persistent and unusual and extraordinary are like antonyms. And I don't see how you can say that something that's been persistent forever. We've had trade deficits every year since 1974. That was the year after I got out of high school. That was a long time ago. And they have not gotten worse. They've been relatively stable as a percentage of GDP for the last 12 years. So that's where there's a factual question. Is the court just going to say, well, the president has said it, so it wins? I don't know how you write an opinion that says that the deficit problem is unusual and extraordinary.
We may see. Go ahead, Bob.
Again, by the way, just because I'm feeling bad enough nowadays about my age, when you graduated from high school, I was already in law school, so knock it off, okay? Anyway, I just want to speak to an aspect. It's not quite the presumption of regularity. I don't think it fits within that concept, but it's something I'm very interested to hear what my 3 co-panelists think if they have a chance to comment on it. And that is, what do we do with the difference between what the administration says in its legal papers and what the president says on Truth Social or publicly? So we have a president who says, Article 2 allows me to do whatever I want. As President of the United States, I can do exactly as I please for the good of the country. Those are close to full quotes. And then he says what it is that he thinks is going on and what he needs to do, typically in his public utterances, very often in Truth Social. So in the Portland case that the Ninth Circuit Court of Appeals just ruled on, reversing the district court that blocked the deployment of troops to Portland, there was a stark difference between what the president said was taking place in Portland and what appeared in the factual submissions before the court. There were differences between the factual submissions on the part of the government, of course, and those on the part of the state of Oregon, but there was a really stark difference between those factual submissions, including the government, and what the president said about Portland, which was that it was burning to the ground. Burning to the ground, war-ravaged, basically sort of 2 steps away from Pompeii. And I have heard constitutional scholars tell me that, you know what, but if the factual record before the court speaks to these issues, then what the president says, perhaps in hyperbolic fashion publicly or in Truth Social, shouldn't matter. But the government attorney in the Oregon case acknowledged that these Truth Social utterances are official utterances of the president, no different in character than if he had spoken them from the Oval Office. And so he took them as part of the record. So what does a court do in evaluating the credibility of these submissions if it decides that what the president says to the public repeatedly by Truth Social is completely false and could never support the exercise of authority under that particular National Guard deployment statute? And the Ninth Circuit just basically blew right past that. And I just don't know how you deal intelligently with a presidency of this kind unless you take seriously and hold the executive to what the president says his actual purposes are.
And so, the court itself has been highly inconsistent about this.
Yeah.
So in Trump versus Hawaii, that's the Muslim ban case, the court said, well, as long as there are legitimate reasons that are supported on the record, it really doesn't matter that the president has been saying these other things. And so the president but then in the census case, it's basically the opposite, that although there were perfectly reasonable grounds for what they did, the proof about what the administration had actually been saying doomed what they said. And in the COVID, the worship cases, which are very close to my heart, since free exercise of religion is one of my big things, early on, the court pretty much accepted some of the claims for why worship services should be shut down. And then suddenly, when it became evident that the casinos in Las Vegas were being allowed to operate full tilt with people crowded, and at the same time that they were shutting down churches and synagogues and mosques, it was all basically the tide turned, and the cases started coming out the other way.
As we know, there's a long-standing challenge here because presidents tend to say things that their lawyers wish they wouldn't. No one in the Justice Department can have been happy when Barack Obama went on Sunday morning television and said, the one thing you need to know is the Affordable Care Act's individual mandate is not a tax. And when Don Verrilli submitted his brief running an alternative argument that Professor Metzger and I helped develop in an amicus brief that the way to defend this thing is as a tax, it was a little bit more of an uphill battle since the president had promised that that was not the case. And so it turns out that something can be a tax for constitutional but not political purposes. And the courts have some resources. One way to think about the travel ban litigation is that the lower courts, not the Supreme Court, struck down the first two iterations of the travel ban as cruder and more proximate in time to the most obviously problematic tweets of the then president. And by the time you got to the third iteration, it had been, one could argue, run through something approaching a more regular process. You could even say that the census case was effectively telling the administration to go do a do-over and see if you can create a record of a more believable rationale. And it was walking a line. One of the challenges of things like the Portland case is because it's all a matter of responding to asserted emergency conditions, there's no time to go do a do-over. We're right in that moment, and what do we make? And it seems a big challenge for the courts.
I would just add, in the Hawaii case, when you say the tweets were closer in time, the public statements were closer in time, they were also, and the court does say this, much of it was when he was a candidate and not yet president.
That's right, that's fair, yeah. Do you want to add anything on this one?
No, I mean, I think it's a real challenge. I think it's also a challenge, and I think you were getting at this, Bob, when you said a presidency of this kind, when social media and this kind of going after people on social media and that dynamic is such a key force that's being brought out in support of the administration in various ways. And so you can't say it's not part of their mode of operation, but how do you regularize it, and how do you treat it? Do you treat it as personal speech? Do you treat it as official speech? Those are very complicated dynamics that courts are not going to be wanting to limit too much on, but nonetheless, I think, as you say, have to respond to.
I mean, one way we might have expected some of this to be dealt with was not so much by judicial policing, but by the observance of norms about how government is supposed to operate, about in a different domain, what the relationship should be, say, between the White House and the Department of Justice. What kinds of things should presidents say, and more to the point, not say, when it comes to the selection of targets for prosecution? It's in the main been thought to be and observed to be a thing that presidents don't do, to remove a sitting United States attorney to appoint an insurance lawyer as United States attorney with apparently the direction to go indict that guy over there, who happens to be a long-running political enemy of the president. Now, one could accept that there's been politicized weaponization of prior Justice Departments, but it still feels, to a degree, like a line has been crossed. Do we think that internal norms of Justice Department independence, of relatively independent prosecutorial decision-making by the Justice Department, not directed by the White House, is that norm gone altogether? Is that as bad a thing as I'm inclined to think it is? And what are courts in a position to be able to do about this? Bob, you want to start with?
I do not.
Former White House counsel.
Yes, yes. And I never had any problem with anything President Obama said. I realize I need to create a record here. I do not think that the norms that we are seeing dismantled, disregarded, in the area that you're describing, as in others, is going to be put back together the way that we believe, or many believe, they've observed it in the recent past and think is the proper way for a government to function. I just don't think it's going to get put back together the same way. Will there be potentially some retreat from the most extreme forms that we have seen, like what you just described? Career prosecutors say the case isn't any good, so somebody who's unqualified to bring it is appointed in their place, they're fired or sidelined, they refuse to appear with the prosecutor in court to bring the indictment, to appear before the judge, to file the charges. I don't know that we're going to see that sort of thing. But I often tell students in some of my classes, the norms that govern the relationship between the White House and the Department of Justice are of relatively recent vintage. They're post-Watergate norms. So over the long expanse of our history, that so-called distance between the president and the Department of Justice has not been generally recognized. And so I think it's relatively new. It's always been under pressure. Each party has continuously attacked the president for either appointing an attorney general or overseeing an attorney general who was in one form or another overly politically responsive to executive wishes. And so that's been pretty consistent. And there's one other factor, and I'll just stop with this. There's something counterintuitive in some respects about the norms, and an example is the following. A president runs on a platform of wanting to see, and let's now move to the left, wanting to see more justice done to the heads of major companies who have public responsibilities they're not meeting. You pick out what it is, pharmaceutical companies, insurance companies. The President of the United States runs on that platform, reads about in the Wall Street Journal some exclusive reporting about some pharmaceutical company alleged misconduct of a significant kind within the zone of what the president attacked on the campaign trail. And the president says, I want to call the attorney general right now and say, you got to look into that. I read the article in the Wall Street Journal this morning, and it's awful. And the White House counsel says, you can't do that. You can't talk to the attorney general about that. And the president says, what are you possibly talking about? I mean, I ran on this. And I can give, chapter and verse of frustrations even I experience in watching DOJ do things that in the Obama White House I would have liked to have some say on and didn't, and I think appropriately for the most part. But I think we have to be careful to say the Department of Justice is independent of the president, because it isn't. Mm-hmm. And what it does, and now I'm filibustering, I apologize. The last point. President Biden complied with the special counsel regulations, allowed Merrick Garland to make a decision about whether to appoint a special counsel. Merrick Garland appointed a special counsel. There's not maybe 0.1% of the American public believes that he wasn't involved in the prosecution of Donald Trump. He wasn't. He wasn't. He followed the rules that were designed to protect departmental independence, but it was his Department of Justice that brought those prosecutions, and most Americans wrongly believe he was almost certainly behind it, or would not have been done had he objected to it.
So he might ask himself, what did that get me?
This may be a heterodox opinion, but I think the special counsel statutes and later regulations were designed to give a veneer of distance where there was no distance. All you have to do is appoint a special counsel that hates the other side, and then they give them complete independence, and all the damage is done. I actually think it's better not to have special counsels, because I think it gives this sort of it enables people to get off the hook. I'd rather know that Donald Trump is actually ordering these terrible prosecutions rather than have like two stages of phony drapery in between.
So I'm going to actually agree with Bob in terms of what actually went on in the Biden administration on this one. But I also want to just, on this issue of norms, I think one of the things that we lose sight of is that norms that are just internal norms, that don't have external reinforcement, aren't going to work. They're going to fall apart. And part of what we have to figure out a better way to do is to externally reinforce those norms. So one of the ways you reinforce the norms of independence of the Department of Justice is Congress, and Congress holding oversight and Congress holding hearings, which they're not doing. So we run right back to that problem. Another way is the courts. And I do think in the prosecution area, the courts have a relatively low damage way of getting at this in a way that also seems to vindicate sort of fairness, which is to dismiss certain prosecutions that really have too much of a record of the president calling for the more suspicious activity in terms of how somebody was appointed.
Although just on that, if we were talking a year ago about how high is the bar to succeed in moving to dismiss charges on the ground of unconstitutionally vindictive prosecution, we would have been describing an extremely high bar. And it may be that what you're talking about will end up sort of lowering the bar because of the absence of any other means of controlling them.
Right, it may. I mean, or it could be that Truth Social just helps us along in making very high bar and showing.
Sure, okay. Glass half full, glass half empty. Yeah.
It would help if our juries were a better system too, but a lot of these cases are brought in a jurisdiction which is like 80 or 90% one party, and that makes, that means we can't really count on that institution as a backstop.
Sure. Another area where the courts are historically relatively uninvolved, I don't think it would be right to say entirely uninvolved, is military power. And Jillian, you mentioned earlier apparently the president's direction of the use of military strikes in the Caribbean against at least alleged drug runners, some of them awfully far away from United States waters and not necessarily, in fact, accurately described in those terms. So this is something that, to the extent it would be lawyered, it would likely be lawyered internally within the executive branch. There will be some combination of civilian and uniformed lawyers within the Department of Defense, and perhaps lawyers within the Justice Department, in particular the Office of Legal Counsel, looking at these questions. Is this a break from how the lawyering of all of that has been thought about in the past, or is it a sort of continuation of the story of the 20th century and the imperial presidency and the reality that almost every single time military force is used, it's done basically unilaterally by the executive branch, by the president, with relatively minimal involvement from Congress?
So I would say, this is one where certainly, if we are going to talk about expansions of executive authority over time, this is an area where executive authority has expanded and you've had lots of instances over Democratic and Republican administrations of uses of force that have been challenged and questioned in terms of whether or not they lie on authority. But there's a difference, in my view, between, for example, a very aggressive reading of the authorization to use military force statute, which is one thing that has happened.
That's the post 9/11, the 2001 authorization.
Yeah. And an effort to bomb ships in the Caribbean where you don't have any claim of statutory authority at all. And instead, it's relying on simply this claim of inherent presidential power, and a real requirement, by the way, in these instances, it actually is a requirement that the president be the one to authorize. And you also, though, have those actions being very much against a longstanding tradition of treating criminal behavior as different than a military attack, both in international law and in domestic actions. Those, again, there's a long trend of executive aggrandizement, but I also think that what we're seeing right now is just different in kind from what we have seen recently. Maybe not hugely different, but it is different.
Of all of the actions, I don't know that I mean across all of the actions. If we were going to divide up, though, sort of like the politics of the different forms of extraordinary executive power that have been exercised in the last 8 or 9 months, I would posit that this one is fantastic politics. That overall, the people love the idea that the president is taking the threat of drugs pouring into the country seriously and is trying to interdict them, including by striking fear into the heart of drug traffickers to get them to stop what they're doing. So does that mean that this is not a problem from a constitutional standpoint?
Do you mean if not a problem from a constitutional standpoint, how do you relate that to popular support?
If this is, to the extent that the Jackson analysis in Youngstown would suggest that it matters, what Congress thinks about what the
Congress
president has done, and here a Congress that is shuttered, if forced to vote, would almost, I'm going to posit, almost certainly authorize this action
Because
by
of
the
the popular
president
support.
because of the political
Right, right.
popularity of it. Should that weigh at all in our thinking as lawyers about the constitutionality of the action?
I think pretty strongly no if they haven't. I do think that, Congress does have an ability to authorize certain uses of military force. I think it's
And
incredible.
the check is the procedural one on having them
Yes,
do it.
exactly. It's critical that they actually go forward and do it.
Great. We could keep talking and will, but in the few minutes we have remaining, we'd also welcome your questions. So if you'd like to pose one as a question, not a speech, then go to one of these two microphones and we'll recognize you. Sure, go ahead.
So, I'll state my priors. As someone that doesn't vote for either major party, if you believe that an informed republic is critical, and you believe, as I do, that both administrations engaged in serious sort of violations of the norms and general dictates of the presidency, don't you think that Trump's sort of like marauding violations in a long-term sense are kind of better than the sort of smug, technocratic, sneaky way that the Biden administration went about it from the standpoint of informing the general public who are not law students, who are not necessarily devoting as much time to these topics as we are, in showing them that we have a serious issue with the sort of liberties that presidents have taken for decades now in exercising their power.
So we could generalize up a little bit if anyone wants to take this. It doesn't have to just be about the current and last administration, but in some sense, is it more healthy for the president to be completely open about extraordinary assertions of authority in order that the polity be able to evaluate them as such? Anyone?
Well, it fits with what Michael was saying about if we reelect Republicans to control Congress, then you might read into that some sanctioning. I guess I don't share your view that the parties are exactly the same, so I'm a little bit struggling on that front. There is something corrosive, I think, also about overt violation of law, and so even if it's good for accountability on your account, there's also damage that is done at the same time. Maybe some people might do that trade-off as well, but I think it's pretty corrosive.
Thank you. Along the same lines, you're talking about slippage of norms.
Maybe a little closer to the mic now.
So slippage of norms, how much of that is slippage of legal norms versus political norms? And how much of this falls back onto the American populace for sort of giving the green light to it?
Have we, in effect, ratified the exercises of executive power in this administration by electing Mr. Trump our president? Michael, what do you think?
Well, I think it's true, just as we did it with electing some prior presidents who were, it seems to me we've been in a deep slide for some time, and I wish I could say that the American people care about these niceties, but I'm not very optimistic. As to the question before, I do think it's quite possible that Mr. Zen is right about this, and that the sort of openness of it might have an effect. That overreach often causes a reaction. The only time I can think of in Bob Bauer's lifetime that that there really has been a restoration of norms was right after Richard Nixon.
Right.
And a lot of that was pretty blatant.
Congress was very active in that restoration of norms, which kind of comes back to this institution
Congress
that we
was
keep
active,
referring to.
and you also had Attorney General Edward Levy,
Yeah.
who was just a giant, and he's actually the person who erected most of the Department of Justice norms that stuck with us for decades.
The one thing that worries me about any hope of having a post-Trump, post-Watergate style kind of revival is, number one, in that period of time post-Nixon, if I'm not mistaken, the Congress was controlled by the opposition party. So they were very invested in scoring points against Nixon. And secondly, we did not have the news and information world that we live in, for better or for worse. People can argue about that. But there was a particular narrative about what happened in Watergate that took hold and controlled eventually. And we don't have anything like that that supports a systematic reform effort that might bring the public along in its wake.
Thank you. I almost feel like there's an implication in the president's enumerated powers of presidential exceptionalism that he, as commander-in-chief, is most qualified person to make decisions about national security. And I know it's difficult for courts to kind of decide whether or not his discretion is used so broadly that because they refrain from deciding things that are matters of political questions. But I'd like to know, and I know you guys touched on this a few moments ago, are there any limits on the exercise of the president's enumerated powers to the point that his discretion feels so abusive that there has to be some sort of way to hold him accountable, especially in regard to his actions in the Caribbean? And now I read a couple moments ago in the New York Times, the Pacific, so.
Michael wrote a whole book on the president would not be king. So what are the limits?
My book is historical. So, it's about how the framers thought that they were erecting limits, but one of the mistakes that they made was to assume that Congress was going to be an independent branch. The framers were just plainly not anticipating the modern hyper-partisan system.
That's really the thrust of the scholarship that Bob mentioned earlier from our colleagues Darrell Levinson and Rick Pildes, that the organizing institutional incentives of virtually the entire history of our constitutional separation of powers, which is to say it took hold not that long after the founding, was much more to do with party identity than institutional identity, legislative versus executive. And so if the way the president's war power, to the extent it was agreed he had any on his own, was going to be constrained was by Congress, the prospects for that turned out to have been always pretty poor. If you want to add anything on this.
Well, just a couple of things. One is just, clearly partisanship and what's happened with Congress is a critical factor here. It's also, though, that we're also seeing very competitive fights for control of Congress. It isn't just that we have deep polarization. It's also that your emphasis on which team you're on is really reinforced when either team has a chance of getting control. And so that dynamic is one that we're in particularly that's been problematic.
That's interesting.
It's interesting that having a very closely divided Congress does not result in moderation, which is what I think most political scientists would have predicted in the abstract. But having a very closely divided Congress turns out to feed the extremes. Yeah.
Part of that must be gerrymandering on the House side, right? We have very closely divided Congress, but we don't have very many House districts that are controlled by moderate voters.
You have both closely competitive, but you also have each of the parties moving more, becoming more ideologically cohesive and becoming more polarized.
Further apart, right.
And the more polarized districts, it's the primary that matters, not the general, and that has a vociferous effect.
Yeah. We've got time for one more.
Love to have it. This kind of builds on a lot of stuff that was talked about. I think just a second ago you mentioned how political scientists kind of expected that moderation, or like as parties sort of realigned along ideological positions, that might help with moderation. And I think, as Professor Metzger, you said a second ago, as we've become more and more, our identities have become wrapped more and more in our partisanship, in our political parties. I think that's led to detrimental effects, and I think one of the ways to slice and dice it is that we have a unique system where, unlike a lot of other countries, you have two legitimately elected functional representatives of the state in many ways. Like you have the Senate Majority Leader who's duly elected and can be oppositionally, can be at odds with the president in terms of ideology, and they're both duly elected. Whether you like Mitch McConnell or think he's Satan incarnate, you can't fault him for taking every measure conceivable to represent his people. How do we solve that problem, where you have, like very few other countries have this model, where you have multiple duly elected people?
Well, I think so. One take on that is you're asking, our system is different from a parliamentary system, but each of these has its advantages and drawbacks. former colleague Mervyn King, who was the head of the Bank of England for a long time, while here visiting, used to marvel at our presidential system during the Obama administration and the first Trump administration. That's so much better, obviously, than the parliamentary system, whereas lots of US constitutionalists say, give me the parliamentary system, including the ability to vote no confidence for the current folks in power if they start using their power unwisely. It turns out that relative legislative inaction and adventurous executive action is a characteristic of constitutional democracies around the world right now, be they parliamentary or presidential systems. And so I don't think in that sense what's happening in the United States is quite that unique. We see a problem of legislative stasis and adventurous executive action as a feature of a lot of Western democracies, as our colleagues on the faculty here, like Sam Sakharov, have pointed out. There's a lot more that we meant to cover and that we didn't. If you all want to stay for another few hours, we can go for it. But in the absence of that, I hope you will join me in thanking our wonderful panelists for a great time.